even if it's at my dining room table while my wife takes the office upstairs. I want to again thank Nikki for helping host and keeping me in line today. Thanks, Nikki. As she shared, my name is Blake Slater. I'm an attorney in the South Bay. I've been practicing since 2012. I recently joined a new firm, Stone Sallus in Manhattan Beach, and we deal with real estate, business, trust administration, wills and trusts, anything to your clients. And I'll share that at the end of the talk. I obviously encourage you to go over your questions and answers, but I'd encourage you all to shoot me an email at bslater@stonesalluslaw.com to see if I could help you or your clients in these strange times. And I'll also say I just did a talk, and I take it everybody's on mute, but somebody went off mute for a second and made a comment that I talk way too fast. So I will try to take that constructive criticism and make sure I'm not doing so today. A few disclaimers. I'm sure a lot of you have been taking advantage of all the great programming that's being provided by the South Bay Association of Realtors virtual education series, keeping its members safe at home. I have, whether it's updates from your president, Brittany Burford, and the board of directors, or recent presentations by Melanie Archer or Eileen Kendall on the legal updates. I watched the talks by both of these great attorneys and certainly want to avoid rehashing a lot of the same analysis of what's going on in California as it relates to COVID. It's especially true these days because week to week, even day to day, the entire legal landscape seems to change. And it seems like your industry, the real estate industry, has had to grapple with the stay-at-home orders a lot between conflicting findings between the county and state officials, whether it's considering your business an essential or non-essential business. We have our own thoughts on that, but we got to listen to the government as it tells us how to do certain parts of our business, which would lead many of you to take your lead from your brokers, which I would encourage you to do on how to handle it. Last Monday, with respect to evictions, the Judicial Council made its findings, which to quickly summarize, because it's so important, to include no more issuance of eviction summons unless necessary to protect public health and safety, no more lawsuits for possession for non-payment of rent. Sorry, landlords. No entry of default in evictions. So even if the defendants don't put in writing why they can't pay or don't even plan to fight the lawsuit, they refuse to participate in it, you're not able to get a default against them, those lawsuits are being stopped dead in their tracks. Trials pushed at least 60 days out, the ones that were already scheduled, any further ones to be scheduled for these eviction trials, at least another 60 days. Getting a comment here that my signal may be poor. Maybe I'll give it a second to catch up. See if I can just shut something down in case that's slowing me down. Okay. And then the last piece of what happened on Monday was that the order won't end for at least 90 days after it's declared that the pandemic is over. Thanks, Mike. That obviously creates at least a 3-month buffer where landlords can expect to not be legally able to collect on their rent with the eviction unlawful detainer realm. A national study was just released that its findings were that just under 70% of households in the country paid April's rent by April 5th, whereas over 80% paid just the month before in March, and over 80% paid in April of last year. So the numbers are ferreting out what we in the industry, I'm sure you and your clients are seeing every day, is that the landlords and the income properties are being hit now, of course, but even prior to these new changes that are taking away landlords' rights to get their possession of their income properties back. So you've all been provided these great resources and content to learn about these orders, and obviously encourage you to incorporate them into your professional and personal lives. So for today, I want to focus more on some of the practical effects of everything going on related to various practice areas, legal practice areas, that may otherwise affect you or your families. Also talk about some of our clients involved in current real estate and business disputes in the time of COVID-19. So I'll start with practice areas in general. I spoke with a number of colleagues to get some insight into how their practice areas are being affected. One of them being workman's comp. This is, generally speaking, people getting hurt on the job, whether it's mental or physical, and they're asking to be paid by their employer for workman's comp, applying for their benefits. All trials, hearings, and depositions were initially pushed out. Now that things are calming down, hearings are being rescheduled by phone. They don't have to be done in person. And lots of the outcome in these cases obviously depend on medical records, right? You got to prove that you were hurt on the job. You got to prove that you're experiencing emotional distress. And who needs to tell us that? We need medical records. We need doctors. And so now what I've been told is that there's being a new push to do medical exams on video. Just saying it out loud, you can see how there's a lot of problems with doctor diagnosing any kind of physical ailments without meeting the person. You've got to meet with them to get the test done. You got to feel them out. You've got to see what the range of motion is. You've got to see how long they can sit, stand, and walk. Getting or giving medical advice without seeing, touching, testing the patient can potentially lead to lots of challenges to the findings, right? It'll cut both ways. So if you're doing it by video, whether you're applying for it and the doctor says, well, I don't see anything wrong with you, that's a problem. Or if the doctor can say he sees a lot from you from just the video, the other side would say, well, if they were in person, maybe your findings would be different. So it kind of cuts both ways. Colleague in the workman's comp realm also did a deposition by a couple depositions by Zoom. So we're using it right now. Apparently my internet is faulting me and it's cutting out some of the timing and making it a little awkward. This is not a legal proceeding, can't be used against me in court. Sorry guys. But you think that those that can, like in a workman's comp deposition where you're trying to get these applicants on the record for what went on, it's real important to get everything on the record. There are some questions right now in terms of Zoom's confidentiality, people being able to crash meetings. I read about one Alcoholics Anonymous, people crashing it and getting and doing ridiculous things. During depositions, obviously, there's a question of confidentiality. But also just practically, right? Let's say three of us were on this right now and one of us was saying what was happening, and I want to object, to interrupt someone from saying something either that I don't want them to say or that they should not be saying because the question posed was illegitimate. It'd be just a practical problem to do it. And we always want a clean record. Even with three people in a room, there could be problems with the clean record and getting it down for the judge in case you have got to preserve your objections. So in that realm, that's what they're doing. And with our clients, that's what they're considering doing, is moving mediations, depositions to video, but it comes with a host of its own problems. In special education law, these are parents that are applying for IEPs, individualized education plans, where they represent children living with special needs and their families to get through the public education system. Notwithstanding schools forced to be closed, the education systems still are contractually obligated to be providing services that parents rely on. So their inability to do so because of everything that's going on are technically violations of these IEPs that are leading to complaints from parents. But getting in front of a judge, that'll take some time. And with us, like I was kind of talking about generally, our clients mostly in LA County, from evictions to business disputes to contested probate trust administration actions. I got an update today that a hearing that was initially scheduled for late May is being pushed out to August. All trials are being taken off calendar. Everything seems to be pushed at least another 4 months. I read an article today that the Supreme Court announced that they're going to be doing oral arguments by telephone next month. But again, there's a lot of limitations in what you can accomplish if you're doing it in those ways. And here, a lot of the headache that our clients are feeling is, when am I going to have my day in court? I need, right in the middle, we're about to go to trial. It's all getting pushed out. Simple procedural matters like demurs are getting pushed out. We had one that was scheduled for April that's being pushed out to mid-August. So a real pumping the brakes on justice, on people getting in front of the judges to deal with the problems that they're having. During my talks with realty offices recently, and those that are provided here, there's been questions about the legality of LA County's stay-at-home order, what Newsom's doing. And I read an article that I wanted to kind of share that I thought was interesting and might be something that your group would relate with. The title is from lawandcrime.com. It grabs your attention. Superstar lawyer sues LA mayor for destroying his business with stay-at-home order. So that sounds real intense, fighting the constitutional fight. Maybe that's not really what's going on. When you read it, it's a lot less to do with Mayor Garcetti. Actually has some interesting practical points that I wanted to go over. Mark Garagos is suing on his own behalf and on behalf of some of his clients, but the lawsuits only have one cause of action for declaratory relief. So it's not any of the crazy, how can the government do this to us and we're being damaged and we want millions of dollars. They're suing for declaratory relief, and it's a lot more specific what he's looking for and what his clients are looking for. Declaratory relief just means you want a judge to order, wants to look at both sides of an argument and say, hey, here's a court order saying we're going to interpret your contract and this is what it says. So normally the attorneys get involved. One side's going to say it their way, they're going to advocate for their client, other side will advocate for theirs. So, Your Honor, we need you to weigh in and let us know what was really meant by this contract. So what do they need the judge to resolve? These are insurance companies that are refusing to pay out claims under insurance policies related to COVID-19 due to non-payment of rent for commercial tenants. So these are commercial properties that are owned by, I believe, Garagos, the attorney, personally, but also his clients that are LLCs that have these commercial income properties, and tenants aren't paying. Obviously, the doors are being shut by law. No one can come in, no one can pay to use the services. And so then the commercial tenants are saying, well, now I can't make your rent, landlord, because no one's buying. And now the commercial landlord is turning to the insurance institutions and saying, hey, I've got this policy. And these, they're called the business income losses. So I've been paying dutifully for years this specific part of the insurance policy that says that if I have a business income loss, you will pay me for that. I'm protecting against that. If my business gets interrupted for things outside of my control, then you guys got to pay me. So specifically the policies included indemnity provisions for these business income losses. The arguments are the actual loss of business income were sustained and the actual necessary reasonable extra expenses are incurred when the access to the premises have been prohibited by the county, by the state. So the lawsuit cites the pandemic, the stay-at-home orders, and the all closing of non-essential businesses. The business is closed due to the order, can't make the payments, and now the commercial landlords are demanding the insurance company to do what they've been supposedly protected against. We were paying that if this happens, you would be covering those losses. And there's a lot of different types of policies out there. The types and amounts that would apply, we got to look at the contract and know, but generally speaking, this is something that they're arguing should be covered. This is likely a lot of the problems that residential and commercial landlords, if they have these type of business interruption policies, they're going to be turning to their institutions too and saying, hey, with everything that's going on, I've been dutifully paying, I need you to step up, insurance institution, and make good on what I've been trying to protect against for years. And this is where attorneys get involved, right? The attorneys will say that you look at the actual language in the agreement, and maybe it said one thing and it was contemplated another. Attorneys are great for that. We'll see how long it takes before this matter gets in front of a judge. Doubt it'll be anytime soon, but based on that, I would encourage each of you, and for each of you to encourage your clients, that if they have those types of policies, to start making claims. Justice will not be swift for months based on everything that's going on. It's akin to how we tell our clients when you've got tenants that weren't paying rent last month. It's a different world now, but as soon as they miss a payment, you've got to issue a 3-day notice. You can't giving them any types of those benefits. You give them an inch, you'll be dragged down for a mile. So it's the same thing. If you've got these policies, start reading them, start making your claims, because here it is. You've got these major players that they've never had these problems before, the superstar lawyer and his clients, and they're being denied their claims. So likely little guys and girls are going to run into those problems too. So we got to get those, read the policy, make the claims, get those wheels rolling to make sure that we're considering how much time it might take before you get what you're looking for, especially if they're going to be looking to deny your claims. You got to start moving through whatever their internal process is. And that brings me to the state of things today. The issues that we're seeing in transactions with clients that can kind of help illustrate the practical issues that the industry is facing. So what about real estate transactions that were entered into in early March or earlier that maybe might be in escrow, contingencies being lifted, that are now being stalled by the coronavirus? How does that affect the deal? And CAR published in mid-March coronavirus addendum amendment, and it makes a general reference to force majeure clauses, which generally are not found in actual residential purchase agreements or purchase agreements in general for CAR, meaning that otherwise it's generally not available to either side. So just generally speaking, we want to think, I'll talk about force majeure in a second, but with everything that's going on, there's going to be one side that certainly wants to push through a transaction of selling real estate, and a side that won't want it to go through, right? So sellers want it to go through. There's a lot of concern about what's going to happen to the real estate market with everything that's going on. So we entered into a contract. You were going to buy it at that price. We got to move it forward. On the other side, buyers who had done their due diligence and thought that an income property was going to be worth X, Y, and Z. Now they're looking at it. They may be feeling a little not so excited about purchasing an income property in a county that just said that you cannot start eviction actions for non-payment of rent. Would generally defeat the whole purpose of why you personally would have been purchasing the property. So sellers want to push it through. Buyers want to get out. So where do we land on that in the transactions? This is why CAR put out these addendums that are addressing the force majeure concept that's not currently in the RPAs and the CAR documents. So the force majeure is generally things that it allocates risk between the parties. If something that you couldn't have foreseen or was completely exceptional, unforeseeable, happens under the circumstances beyond the control of the parties, right? These are the acts of God provisions. If something, if an act of God happens that prevents me from performing, I should be let out of my performance under the contract, should be forgiven or waived because I can't do it anymore for things outside of my control. That's just kind of the general layman's explanation of it. And so here we could make the arguments, right? The global pandemic that's ravaging all pieces of the economy and people's lives, health and safety, there are arguments as to whether it was foreseeable. We're in the middle of it, and it's something that we're going to have to deal with. And so the question then becomes, though, in these transactions, where do we go? How can we use it? The addendum says that it discusses what? It discusses postponing close of escrow unless the parties mutually agree. So suspending the performance during the force majeure, during the act of God, that's really what's contemplated. And that certainly makes sense here, right? What's going on is it's difficult to meet with people, to get notaries, to go and inspect the properties, to do inspections. To do any of that stuff is almost impossible. And so what the addendum generally contemplates is, all right, well, we need to hold off and let everything become safe for everyone to carry out the transaction. And it's really a postponement, because we expect that once the health crisis is over, then we'll be able to move forward with the transaction, because then the orders from Gavin Newsom will disappear. Tenants will be having to pay their rent again. The real estate market will stabilize, and we'll be back to the whole reason why we were entering into the transactions, because that was the expectation. And so it does not excuse the non-performance. We need some time for things to level out, and that kind of makes sense in the COVID context. So in these transactions, what's happening now when we're in the middle of it? There's got to be a correlation to the coronavirus issues that are affecting the deal. So what might it be? It could be things like inability to fund the loan and close escrow due to loss of income, right? As an example, that's one where there's kind of a direct correlation. This can, a direct correlation, this is what was happening before the most recent order, is that if the tenants give written notice to the landlord within 7 days of the rent becoming due, that they could not make a payment because they lost their job, or they were taking, because the kids weren't in school, and so they couldn't go to the job. If there was that correlation, then you couldn't be evicted during those times if you have documentation of it. So that's kind of, again, back to the RPA. If you aren't able to fund the loan because you got furloughed, you got laid off, and that's the reason why, then that would make sense. There's the correlation with CV. But what if contingencies were already removed? And this is happening for one of our clients, and there's a lot of issues because the coronavirus is not preventing the sale. Right? The act of God isn't preventing the parties from carrying out the transaction, just giving headaches as the timing. And the buyer, like we said, seller, very happy to have locked in someone at a price with all the questions about the real estate market. But the buyer, they're going to say, no, I didn't contemplate this. I contemplated inheriting tenants that would be required to pay rent. So that's how this is how I want out. So the problems are that the RPAs generally do not have these provisions. That's why there was an addendum to add them after the fact, which would be helpful on future transactions. But in the transactions now, how does it apply? I mean, the addendums don't apply because they weren't signed. They weren't in existence. CR didn't provide them. But there's other theories, to get out of contracts, just generally speaking, which is what force majeure plays to, like impossibility, impracticability, frustration of the contract. But with these types of transactions, they're likely inapplicable because, again, the contract's not impossible to perform generally. And it's difficult to argue unfair to hold the parties to their obligations because, well, I'll play devil's advocate, right? If you say, well, I was purchasing an income property that was going to have tenants paying me rent, which was the income. So now that's not happening. I don't want it. What the orders are saying is there's a forbearance. It's not a forgiveness. The tenants still owe the money, but the counties are giving them time to come up with it. And so right there, the argument would be, well, you're still going to be getting your money even by everything that's going on. You just might have to wait a little bit, just like everybody else. So to say that you can no longer perform or it's frustrated the whole purpose of the contract, it's difficult. It's a difficult argument if they had not agreed to sign off on the addendum. But again, even the addendum, unless they were going to agree to cancel the contract, and with such competing interests, very unlikely that I'm going to be hearing about parties doing something like that. So let's get back to what happens now. So we've got a buyer who wants out with everything going on. He released contingencies. What can he do? You look to the contract. With all CAR agreements, generally if you initial it, you have to go to mediation before arbitration. And always an important reminder is to make sure that you're doing everything you can to get your attorney's fees. And in California, the only way you can get your attorney's fees awarded to you is if it's provided by contract or by statute. Here in the CAR agreement, to get your attorney's fees, you have to first request mediation, go through mediation, non-binding, and then go to arbitration. And then a prevailing party can be awarded their attorney's fees. Okay, so let's say we've got this fight over the deposit and we want to do mediation. So now we're back to part of the problems of where we're at today. Any problems with filing for mediation during a global pandemic? Just like everything else that's going on with the courts, we have to figure out the comfort levels of the parties with going through mediation and arbitration remotely. I can't sit next to my client. I can't explain what the mediator is saying without the mediator being there. I can't show documents if the mediator is saying, well, they're saying that there's an addendum that says, if COVID, then we can cancel it or extend it, or we have more time. And I'm not able to just say, here's the contract. It's not in there, right? There's the kind of the loss of the back and forth because you're not in the room to really more effectively deal with what's going on. There's inherent lag, just like I was experiencing earlier, of not being in the same room to show evidence. And so whether you want to or not, and we have clients where they're deciding whether it makes sense even to go forward right now with any type of mediation or arbitration procedure because of all those handicaps. And there's not really a winner on either side. It's just extra time that going through with the process now with all those unknowns. Generally what I'm seeing is things are being continued. There are clients that cannot wait though, right? Especially, I don't do family law, but you could imagine in the family law realm, time affects, it's not just about money, it's about life and livelihood. And that was another practice area that I was reading about is we live in interesting times, and some people may call facts fiction and fiction facts, and it doesn't really matter which side you're on. But if you think about it, and let's say you've got a mom and a dad who don't agree with what's going on, how serious it is for X, Y, and Z reasons, it's something that parents should be thinking about, that if one parent is taking seriously COVID more than the others, then is there an argument that if you know that one of the parents is violating stay-at-home rules, that they're putting a child in harm's way? Could they be arguing to a court to say, hey, these are extenuating circumstances, and with all these things going on, I now have more proof that they're violating stay-at-home orders, and I want a judge to look at this and protect my son or daughter from being exposed to that. Those are those things where your personal thoughts on what's going on really become irrelevant. And it's an easy argument, I think, for an attorney to make, to say you need to be thinking about what you're posting, what you're doing during these stay-at-home orders, because it could certainly be used against you in that area. Here it's the same thing with our civil clients, is to say, we want to get them on the record. We want to do these depositions. We want to do the mediation. But if we're doing it to kind of push to get to trial, right now there is no trial. All the trials in April were pushed out. It seems like they're not going to be rescheduled till August, because they're going to first be focusing on the criminal aspects. The criminal matters are arguably more important because it's people's freedoms as opposed to financial disputes. And again, people can have different takes on that, but generally speaking, that's the thinking, is that once things kind of get figured out, that those are going to be the first ones to be addressed. But it's a lot of hurry up and wait. And these are just some of the headaches and concerns, reasons for all of us to be alarmed. But thankfully, this talk is not all doom and gloom. I have seen, and I'm sure a lot of you have too, the news reports of the landlords that are waiving rent entirely. And even if it's just for the headlines, and good for them that they're able to do it, not all our clients are mom and pops that this is their own, one of their major sources of income to support their family. So, doing something like that isn't always practical or even available, but it's happening. So it is something to say that there are they didn't have to do that, right? So if they didn't need the money, they certainly didn't need to waive people paying it. And the one that I read, I think it was a guy in New Jersey, it was like $50,000, and he said, focus on your friends and family, no questions asked. Not everybody can do that. It's certainly nice to hear it. From the property managers that I've been talking to and the notices that I've read that they've been sending out, that they've been very open and understanding with the tenants, because the pandemic is affecting all of us, and we'll need good tenants once again when everything settles down. And I think it's another thing to think about is, to not, we don't want it to be interpreted that the power is being taken away from the landlords. They still owe the rent. And so I think I see some questions about forbearance agreements, working with them, letting them know that your clients know what's going on, you're sympathetic, and trying to also be reasonable to say, but look, if none of you, no tenants start paying me and I can't pay the mortgage, how am I going to take care of your utilities? It's going to become a domino effect. So let's be in this together. Those open types of discussions are certainly more easier to keep the tenants from feeling like they want to stick it to the landlords and say, well, I'm just not going to pay because this guy or girl is, hiding the ball. So whatever, I'm not going to pay because I know they can't come after me. I think the open dialogue can minimize a lot of those types of nightmares. Another thing that, from what I've been seeing in terms of what's good for people in general, families in general, with all the unknowns and difficulties, may lead to people deciding to settle and move on and focus their time and money on their families and their well-being. So maybe not so good for attorneys in general, certainly great for my clients. I've got a case with some title issues where a client has power of attorney over the mother. Mother's in a nursing facility that will not allow visitors except for emergencies. And she was in the middle when all this stuff went down of getting a VA loan approved, and got approved. It's fair market value. Wanted to purchase mom's property from mom, use the money to fix it up, have a place for her when she leaves her home. And it became a bunch of problems signing with the power of attorney. I don't know how many of you have dealt with it, but sometimes title won't insure. And if they have questions about those in the transaction, even if you disclaim, I had a case where I had a power of attorney that literally said the agent can use this power of attorney to self-deal. I mean, it could not be any clearer that it was a brother-sister relationship, and she had put all these documents together and put in the brother, she didn't have a family, put her brother in charge to do whatever he needs to do. She became very sick very quickly and was in a coma, and she did not have, she owned real property. She didn't have it in a trust, she didn't have it in joint tenancy. So her brother, who was her only heir, was about to go to probate, had this power of attorney that said that he was entitled to self-deal. And so we did a grant deed transferring the property to him, which would have gone to him anyways, right? He's the only heir, but if we waited, if she'd passed away, then going through the probate process, that's where attorneys take, gross value of the estate, takes time and money. First of all, the deed was rejected at the rejected at the recorder's office because they didn't like how we titled it. I got a rejection sheet that said, this is how it needs to be titled. We redid it, rushed it back. It got rejected again because the sheet they gave me wasn't, that told me the titling wasn't the proper titling. It took 4 times, got it taken care of. But then she sadly passed away, and then we went to go sell the property, and we got a pushback from title, and they said, well, the transaction was self-dealing, even though the power of attorney said that you could self-deal. So back to this case, I've got a power of attorney, and we're getting pushback. They're saying, well, they're self-dealing here. And I told my client, I said, look, I've been down this road. I can talk to their legal team. I can, we can get into this stuff. But if mom understands what's going on and we were doing it out of convenience, then this is no longer convenient. So maybe you should try to see if we can work out getting mom in front of the notary. And supposedly that's happening this week. So instead of turning up that legal machinery, even if it's not right, the client decided, and we encouraged her to do, is the path of least resistance. Mom's on board, just work with them to get her to just sign it, and then we'll carry out everything else and just get it out of the way. I've got another business dispute client that's been fighting for almost a year and a half with an ex. There was a huge fallout. The partnership fell apart. Claims ownership of the joint home. This is a lawsuit that pains me. It's one of the reasons why I personally don't enjoy family law, is that a lot of it is not about the law or logic. It's a lot about emotion. You're just too close to it. Everybody's just too close to it. Emotional turmoil, fighting to be the one right, fighting to win. So this one is kind of that bloodbath case that normally makes litigators very happy. But last week, the first time in its inception since like early June of last year, the other side came out of nowhere to discuss a settlement. All my attempts to settle were met with ridiculous counteroffers. Now they're coming to the table and saying, hey, can we work something out? And my client seems to think it's because of the other side lost their job and there's no income and they can't finance the fight. But that's okay. As long as we're getting to where we need to go, we'll see if we can get them to stick to it. So just a couple of those cases where because of everything that's going on, because of all the unknowns, the uncertainties, the scary things that are happening out there, loss of income, loss of jobs, loss of income properties, this kind of the domino effect that everyone is feeling now, there are clients that are choosing to say, look, maybe paying the attorneys isn't the best way to do it. And I tell clients all the time, and it's something that I've been talking about with these problems. What do we do with, these tenants that aren't paying? You could pay an attorney to fight them for it, or you could pay to get your property back. It's another painful option to think about, to say that if we've got a bad tenant, how to get rid of them, pay to relocate them. But it's something that I always say, if I were in your shoes, what would I want to do? Do I want to pay Blake to fight the noble fight and really, advocate for me and make all the great arguments and show them what's what? Or should I just be paying to say, you know what, I want to move on from this. This isn't what I want to focus my time and energy on. I know a lot of us have a lot more time on our hands, being at home with family, not able to see friends. It's because of that reshifting of the priorities. Thankfully, for everyday people, there are these cases where it's becoming, let's just focus on how best to proceed without adding these additional stresses and paying more money to fight things. That really, I prefer to focus on what's important. And so some things to think about for you and your clients is that with all the stuff that's going on, try to keep an open mind about it. I've been asked multiple times by realtors that are asking, what if it's difficult, right? Right now, how are you supposed to go and find people that are looking to purchase income properties, or even someone to sell their home if there's concerns that they're just going to be waited out for the market to crash and the prices to drop? It's uncomfortable. And so we want to try and give them the best information you can. And like I usually say in my talks, you hate to hear it from an attorney. The most annoying thing that we can say is it depends, but so much does depend. It depends on what happens this week, whether they're going to be making more changes with the evictions, the stay-at-home orders. It's going to depend on your stomach for the fight, depend on the need for the money that why they're selling the property. And recent advice that I was talking with a realtor was, he was listing multifamily homes, is to say, look, right now it may seem ugly to purchase an income property, but we all expect it's going to be temporary. And maybe a seller is going to be more incentivized to sell because soon at a discount, because they don't know how low it's going to drop and how long it'll take for the prices to get back up to where they might be comfortable to sell it in the future. So you might be able to find some sort of sweet spot that I would certainly encourage to incorporate loss of income from the tenants for a period of time. But to say that doing that, there is a way that you could find a number that works for both sides and that it could still happen. But really the most important thing would be to have all that information thought out, how it affects the deal, how things may change. Like I said, every day things are changing. So for you, the most important thing to be is, I think what you're doing, I think it's a little self-serving to say attending my talk, but doing these talks and immersing yourselves. That's why I watched a couple of the talks by the attorneys on here, from Melanie and Eileen, is to stay up on this stuff, because having that information, what I always try to do for realtors is to share information that so you guys and girls can be dangerous. Don't give legal advice, because they will certainly hold that against you if it doesn't go their way. But just to have some knowledge of what's going on so you can kind of point them in the right direction. And whether it's just sending them to an attorney that you know and you trust, or sending them to the news articles or the orders that are being released in the county, just making sure that the clients continue to turn to you for that information, because you're in the weeds on this, and there's going to be a bunch of things that normal buyers and sellers won't necessarily know. They won't know what their expectations are now that they're locked in a deal as the buyer. What kind of arguments can we make to try and get out of it? You should be talking to an attorney. Now you've got some ideas on some of the problems, but at the same time, if you've got clients that are looking to buy and sell, it still could be a good time to do it, because just depending on which side you're on and all those specifics, as you know, no two deals are alike, no two cases are alike. Trying to evaluate what's most important to the family and what their goals are can help you advise them accordingly, especially with what you're doing. Okay. I am going to switch over to the questions. So this is from Rosie. If a tenant asks for forbearance rent payment, how long can the landlord collect in the past rent if they agree to pay the back rent when they go back to work? So right now, what do your deals that you're going to be doing with the tenants, just go for them. They're not preventing you from, the orders that are happening aren't preventing landlords from getting paid. They're still saying that there's no forgiveness. It's that they have extra time. I think LA is 12 months, other counties 6, to pay back the rent once everything calms down. If you're doing a forbearance rent payment, and this is something I would encourage everyone to think about with these income properties, is to say, hey, I'm not letting go of the rent. You're going to still pay it, but I know you lost your job. I know you're using your money for your family because the kids can't go to school, that sort of stuff. And so we're going to be entering into a forbearance agreement, which is saying, like what Rosie is saying here, here's half the rent, you could pay later once things calm down. The only thing that the county and the government is saying is that you cannot use the unlawful detainer eviction process to sue someone right now for non-payment of rent. So what you put into your agreement, do your agreement however you want, but it just becomes a practical question, is to say, all right, well, I'm going to half your rent this month. Does that work? And they say, yeah, and then they don't pay. then you've got another contract that they owe rent that you can't collect on. So what I've read too, it's possible if they owe rent and you're not focused on possession, you're focused on getting a judgment for the amount that's owed. Maybe you know that they have the money and they're just trying to stick it to you because they can. Depending on the amount, you could potentially go to small claims court, not for possession. Generally, you could go for a breach of contract claim for the amount that's due. Generally speaking, landlords aren't doing that because if they're not paying, you're not going to find the assets to get that money paid back. But it is potentially an option to say, well, I think that you have the money. I think that you're just messing. I know you work from home. There's no reason that you can't pay. So let's go to small claims court. I'll try to get a judgment. Then you got to figure out whether it's worth your time and money to go and collect on it. But normally that's not necessarily for the realtors, but for your clients to think about. Okay. Got a few from Rosie. If a buyer removed all contingencies and the buyer and lender is asking, the buyer, sorry, we just got it, one removed. Thanks, Nikki. Buyer is asking for an extension of contract and the buyer asks the seller to sign the addendum. Seller does not agree to sign it. However, the seller agrees to the extension. What is the seller liability? I mean, generally speaking, even if they sign the addendum, unless it's canceling the agreement, we need some more time to do stuff. So if you're saying that they're going to do an extension, I'm not really following what the seller liability necessarily would be, but make sure everything's memorialized in writing. The extra time is really the idea behind force majeure, unless the parties are going to cancel the contract. But I don't, because of the competing interests and why, like I said, acting against each other, the sellers are going to want to hold you to it and the buyers aren't. I don't see that happening. So I don't really see a seller liability. It's just a practical consideration on whether something that the buyer and seller want to do. Why would the seller agree to sign the disclosure if the buyer removed all contingencies? Yeah, I mean, this is that's a great question. It's if they've already released the contingencies, why not just agree to an extension? They could do that, right? Each side could do that. That's not really the big problem. The problem is that the buyer is saying, sign the addendum and cancel the contract because this isn't what I bartered for. This is an act of God. I shouldn't have to buy this property anymore. That's the problem, and an extension isn't going to fix that problem. So that's where there's more of a question. I've had okay, this is from Shelley. I've heard that tenants will have up to 12 months to catch up on their rent once this is over. Can you speak to that? Is the city of So these this LA, I believe they have 12 months. City of LA, other cities have 6 months. It's something that's likely going to change. I would encourage you to stay up on it. It's going to be some time, and it's likely going to change again. So for right now, that's my understanding. I believe the one that Eileen did on Friday talked to that, so maybe you could take a look at that as well. I think she broke down some of the other cities as well. Without question, is from Anonymous, the courts will be overloaded once open. Do you think that there will be temporary courthouse or additional hours set up to deal with the backlog of court cases? Absolutely. What I've been reading is they've been either considering or actually reaching out to recently retired judges to come and help. Right now, all they're doing is pushing everything out and trying to keep control. They're going to refocus on the most important, right? Our cases are always the most important, but generally it's the criminal stuff, public health and safety type stuff are going to be the first things that get going. But yeah, they're certainly going to be looking at bringing on more personnel to deal with it. They have to, especially with the social distancing, because everyone's got to be spread out. So you can't have as many people there, but then we have less people to do the work. So they're likely going to need to be expanding to deal with the influx of what's going on. Lynn, are you saying the force majeure will not apply for a buyer breaching a contract 2 days prior to close? All cash, no contingencies, walkthrough done, down payment wired in. Buyers decide, nah, they don't want to buy 2 days prior to close, which was supposed to be 3/18. So that's, again, hate to hear from attorneys, it depends. But, I have to look at the contract, and we could certainly talk about this after. I could see if there's some way I could help. But generally speaking, if they breached it, there were no contingencies. Yeah, I mean, just saying no, if the act of God is the only reason, the act of God of what's going on right now, from what I'm seeing and the way I'm evaluating it, is that it's a time thing. It's not a way to cancel the agreement. They can maybe make an argument to say that it does, but I look at that as a stretch. It's NCAR, like I said, their addendum kind of goes along with that based on the language in it. This is from Deborah Lynn. Can you confirm during this COVID-19 time, did I hear correctly, to still issue a 3-day notice for missed rent? If yes, would you still issue a 3-day notice even with written notice from the tenant? That's a great question. What you're not allowed to do is file a summons, which you need for any lawsuit. They will not issue a summons in an unlawful detainer. So in terms of the unlawful detainer process, that's step 2. Step 1 is they don't pay, you hit them with a 3-day notice for rent. I'll tell you, we served the tenant with a 3-day notice for non-payment of rent last Wednesday. So it was after these orders. I would still do it, because you're going to still need written proof that you were doing your due diligence, right? Because if you don't hit them with the 3-day, then you will have no document that's going to you're going to base your eviction on in the future. When that future is, that's a different question. But I would still say we got to keep our documents in order, so that when we hand it off to the attorneys, or ideally being drafted and served by the attorneys, that it's got all the right language in it, so that we could hit the ground running when things turn around. So you still will need to do your 3-day notices. The problem will be, hey, if they don't pay, Blake, why did I pay you to draft and serve a 3-day notice? That is a fair consideration I would ask clients to think about. But another way to think about it, we're all in the weeds on this stuff. Tenants may not be. And it's not that they don't owe the rent. They do owe the rent, but you can't use the unlawful detainer action to go after possession in that the faster way to go and get that. So they still owe the rent. So serving them with the 3-day, that's what I would do. From Tommy, have you heard anything about mortgage forbearance for a landlord being frowned upon by lenders, and that they will treat the forbearance much as they do a short sale? Negative impact to the credit score. So it's a great question. I anticipate, based on they are asking landlords, property owners to shoulder this crisis in terms of rent. They're just saying, too bad, right? This is what the government is saying. They're saying, look, we got a bunch of fires to put out right now. Those that own income properties, they're going to get hit with it. We talk about, there's a domino effect. We're talking about mortgage forbearance. This will be real specific on each institution. It seems like some of the major ones, the major banks, that they're going to be offering some sort of options to it. It'll be very specific to the amount that you owe, which institution that you're at. But so I can't give, that's a lot. It depends, a very lawyerly answer. I don't know, because it'll depend on all those things. But it is not, I would say it's certainly within something to think about, that this is another area they're going to have to tackle next, is to protect people from foreclosure, the government stepping in. All right, from Nancy. Question on serving 3-day notices. Even though we are not able to evict, should we continue to serve? There you go. I just went over this with Debbie. I would certainly encourage you to keep serving the 3-day notice, because you need that to move forward with the eviction. So that's what you're going to have to do. So I would continue to do that. Have you or your clients seen prices decline? I haven't noticed that. I haven't noticed that across the board. This is from Lori. I haven't seen that necessarily. I have seen, like I said, the the sellers that are not letting go of the transactions despite COVID-19, but it's certainly something that we're going to need to keep an eye on. Mariko, do you know how eviction lockouts are being handled right now for the cases that have already concluded in court and are simply pending a sheriff case? I hate to be the bearer of bad news on this, but I was talking to property managers in early March that had done this, right? So we're saying COVID, all this crazy stuff going on, but forget that. What about the the tenants that just didn't pay rent, or it was a nuisance, or whatever it was, and they weren't affected by it, so they're still doing the lockouts, right? I was told in early March that there were sheriff's lockouts, and the sheriff said, we are not rescheduling these until June. So right now, the lockouts that are being handled, the pending sheriff lockout date, it will not be happening from what I've seen until late. They won't start doing them again until late May. So if that's what you were hoping for, to get them out, these are those times where, again, I hate to say it, cash is king. If there's something that you can work out with a tenant possession, we need possession. I know that. Sheriffs aren't helping you with that. So trying to work something out with that tenant, even if you have the eviction against them, could be something to do. All right, so we got a couple. What if there's no federally insured loan on the property? So the federal insured loans, they're being helpful, but yeah, this is so the if you've got private, you're working with private people that you did deeds of trust, promissory notes, you're doing the mortgages with, and it wasn't with a major institution, that's no man's land. So where the forbearance or what you're going to be able to negotiate with that, that could certainly be a problem. Okay, so let's go to anonymous. In the multifamily space, there is a good amount of private hard money, talking about being in the weeds. Rosie, to be clear, if tenants and landlord have a forbearance agreement, the tenants will pay rent after they return to work, and they are not paying the rent in the meantime, you would still send a 3 days notice. Again, the only way you're going to be able to do anything about the non-payment is you've got a paper trail saying that you were requesting rent to be paid. And again, the government's not telling you it's not owed. The government is telling you, landlord, you cannot use the courts to go and get it in the unlawful detainer action. That's the problem. So I would continue doing that. It's what we would be saying despite everything else. The only thing that's changed is the landlords have been handicapped in their ability to move forward with the eviction. That's it. So I look at it as everything else should remain equal. If they don't pay, you need to get it on the record that you served them, you gave them notice that they needed to pay, and they didn't pay. So then all that comes back down to is making sure 3-day notices are properly drafted, they're properly served, so that when we get past this crisis, that we can hit the ground running to go and get what's owed to you. All right, Mike Meadows. Can the buyer back out of a contract once all contingencies are removed? Both parties have signed the COVID-19 extension agreement. Buyer's argument is that the value may have declined from the opening of escrow. What argument would the seller have? So I don't have it in front of me, but the COVID-19 extension is really just an extension of time and no other considerations that I recall. And so the buyer can argue, and it likely makes sense. This is happening right now, that the value may have declined since the opening of escrow. When they signed off, contingencies were removed, that everybody did their due diligence, right? So the things that have changed, I mean, this could, without COVID, this could happen. Without COVID, the real estate market could have been hit in the middle of a transaction, and then you can say the value may have declined. I mean, that's, right now it seems more palpable because of everything going on, but generally speaking, that's the whole point of the contract. On the flip side, if the value had shot up, seller would say, hey, I want out of this thing. I could go get more money from the next guy or girl. That's why it's the whole point of the contract, is to prevent these types of things from happening. So COVID-19 extension is just going to be, we're going to do this thing, but we're going to do it later unless they canceled the contract. But because of how diametrically opposed buyer and seller are going to be to that, I don't anticipate we're going to see a lot of that. And then Shelley, if you rent to a tenant now, are they still under the rules for the tenant if they stop paying? I think your question is, are they still bound by the contract, by the other provisions of the lease? And the answer is yes, which is awkward. On the flip side, we're talking about, does the tenant can they still not have co-occupants? Can they still not have pets? Technically, they can't, but you can't evict them for those things, so that's the problem. But the other awkward part of that is the flip side. What about the landlord? So tenant stops paying rent, and the landlord, let's say the landlord's supposed to cover utilities. What if there's upkeep? What if there's mold problems? What if there's pests and your tenant who's not paying rent because of everything going on? Does the landlord still have to go do it? You betcha. They didn't take anything away from the tenants, and I would say you'd be setting yourself up for problems if you don't act under it. So contracts are still in play. Landlords are just having to jump through some more hoops to get it done. So I think that's about it. Again, my name is Blake Slater from Stone Sallus. Email is bslater@stonesalluslaw.com. Anything else, Nikki?
Blake, you want to spell that email?
Yes, it is BSLATERSTONESALLUSLAW.com. Thanks, Debbie. Thanks, Len.
Great. Thank you. Thank you so much, Blake. We appreciate it.
No worries. Have a good day. Bye, guys.
Bye, everyone.